Good afternoon. I'm Gary Jenkins. I'm Dean of the Law School, and I am thrilled to welcome you all here and to say thank you for coming, because this is an amazing day, gathering to celebrate a terrific person, a terrific friend, a terrific mentor, teacher, scholar, administrator, and to celebrate a terrific career. Of course, I'm talking about Professor and former Dean Bob Stein, class of '61, and his 50 years on the faculty of Minnesota Law. That's a golden anniversary. Take that in, 50 incredible years. Plus, there's the additional 3 formative years that Bob spent as a law student here. Now, as many of you may know, we are celebrating the 135th anniversary of the law school this year. So that means that Bob has spent 40% of our existence at the law school. So he hasn't, though, just observed the law school during this time. Bob has contributed greatly, perhaps more than anyone, to us being the preeminent institution that we are. Bob has been a true lawyer leader who has shaped and continues to shape this great law school, legal education, the profession, and the law. After graduating from Minnesota Law in 1961, Bob returned to join the faculty in 1964. He served as vice president for administration and planning for the university from '77 to '79. And then he, of course, served as dean of the law school from 1979 to 1994. And then starting in 1994, first on a leave of absence from the faculty, then we'll call it an extended leave, he became executive director and chief operating officer of the American Bar Association. That's the ABA's most senior professional administrative post. And upon concluding that important work in Chicago, he returned and rejoined the faculty in 2006 as the Everett Fraser Professor of Law. Through his work as a faculty member for more than 50 years, his 15-year tenure as dean of the law school, and his 12 years at the helm of the ABA, Professor Stein has demonstrated a deep commitment to global engagement, international and US legal education, as well as the rule of law. And in doing so, he has changed our law school, and he's changed the world. He's made an enormous difference to the law, to legal education, to the law school, the university, through his scholarship, teaching, and service. He's a nationally recognized authority in the areas of estate planning, trust, and probate law, as well as the area of rule of law in the global context. In addition, Bob has pushed the law school to become a pioneer in international legal education, long before this focus became widespread in our discipline. While a number of international initiatives were sparked under his deanship, he founded our longest and deepest student and faculty exchange program with Uppsala University in Sweden. In fact, its impact, that exchange, has been so profound that Uppsala bestowed an honorary degree on Bob in recognition for his enormous contributions. Now, his successes as dean are too many to mention. They would take up the entire time here, but he was a consensus builder, an enormously successful fundraiser. He helped to grow our clinical programs and change the makeup of our student body, recruited great new teacher scholars to our congenial and intellectually vibrant faculty. In short, he is a legend. And then during his time as executive director of the ABA, his tenure was widely noted for its focus on rule of law development around the world. But that's not Bob's only method of influence on the state of law. In addition, he is a longtime commissioner from Minnesota to the Uniform Law Commission and served as the commission's president from 2009 to 2011. He's also a longtime member of the American Law Institute, has served on its council, which is its leadership board, for more than 25 years, and been an advisor to several of the Institute's restatement projects. He's a fellow of the American College of Trust and Estate Counsel and the American College of Tax Law. And then, of course, he's taught so many of our distinguished graduates, our distinguished lawyer leaders who've gone on to become judges and politicians and business leaders and nonprofit leaders and great lawyers across a large number of fields. He is a past president of the University of Minnesota Alumni Association and served as a charter member of the Minnesota Law Review Advisory Board. He's even served as the university's representative to the NCAA, the Big Ten, and the Western Collegiate Hockey Association. I mean, what hasn't Bob done? In 2017, he received the university's President's Award for Outstanding Service, and in 2016, he received the additional university title of Distinguished Global Professor. And then Bob has even used the power of philanthropy to continue to impact his beloved alma mater. He and Sandy have been loyal and generous benefactors in so many ways, most notably the Stein Scholarship, which was started in the mid-1990s by the alumni community to honor Bob's tenure as dean. They have further strengthened that fund, and they've also created the Stein Lecture Series, which has brought and will continue to bring high-profile speakers to the law school, including most recently the wonderful visits of Chief Justice John Roberts in 2008 and Associate Justice Elena Kagan in 2019. What an enormous impact. Bob's leadership, his vision, his efforts have transformed our law school. The vital global relationships, the scholarly impact, the towering professional service have transformed our profession. And when you think about it, in his 50 years, he's actually led several professional lives. But Minnesota law has always been at the center of that professional life. And on a personal note, I just want to thank Bob for his warmth, for his friendship, for his advice, for his support. It's been a personal treat to work closely at the law school with him, but also our work together on the Uniform Law Commission and the ALI. And I can tell you that Bob is a rock star in those circles. There's no question that legal education as a whole, the legal education provided at the University of Minnesota Law School, has changed throughout the past 50 years. But through it all, Bob Stein has led us. He's led us to global engagement, to impactful partnerships, to advancing the rule of law, and to advancing the values of our profession. Please join me in congratulating Bob on this glorious 50th anniversary and in thanking his family, his wife, Sandy, and his many extended family who are here with us today, including their 3 daughters. Thank you all for sharing him with us. Bob, congratulations. Hold that for 1 second. We have some gifts before we hear from Bob. Oh, okay. A small token of our appreciation. for his leadership. So first off,
Oh my gosh. Thank you.
something.
Oh, this means a lot. Thank you very much. Thank you very much. Okay.
A photo op.
Okay. Here you go. How's that? Okay.
Great. Now, Bob thinks we're about to turn it over to him, but we have a little surprise. We have a short video. Some friends and colleagues are going to pay tribute to Bob, his impact on the university and the law school, and then we will turn the podium over to him. You might want to sit down.
A sincere congratulations to our friend, my friend, and our colleague, fellow lawyer and alum Bob Stein on his 50th teaching anniversary. Bob is one of the foremost legal minds of our time, a leader and trailblazer at the upper reaches of higher education, government, and the law.
As a professor starting in 1964, as a university administrator in the 1970s, as visionary dean of Minnesota law for 15 years, through his 12 years as executive director and COO of the American Bar Association, Bob has made an enormous impact on law, legal institutions, and the rule of law.
Before Bob became dean, Minnesota was all too often a place where famous law professors got their start and then moved on to one of the top-ranked law schools. Bob changed that dynamic by raising funds to support numerous endowed chairs. These chairs helped Minnesota retain rising stars and indeed hire them away from other schools.
He wrote a book in 1978, his history of the law school, titled In Pursuit of Excellence. And that seems to be an apt description of Bob's own career as well as the law school. And I think about his work on the Uniform Commercial Code, his leadership of the ABA, all the public service that he's done. Really, we, the law school, the university, the state of Minnesota, the country, owe Bob a profound debt of gratitude.
Bob Stein was the dean of the law school when I joined the faculty in 1982. One of my responsibilities was to serve as director of the law clinics. This was a challenging job because clinical education is rather labor-intensive and expensive. But with Bob's strong support, we laid a foundation for what is today a world-class clinical education program consisting of more than 20 teaching and practicing clinics.
Bob was the one who coined the often repeated phrase, the University of Minnesota Law Library is the jewel in the crown of the law school. As dean, Bob ensured that the law library had the funding and the facility to attract an exceptional staff and support its mission of providing outstanding services to current and future generations of law students and faculty. The lives of countless students and citizens have been shaped by the ideals he holds and the example he embodies. The Stein Lecture is a great example of this, and I'm honored to recognize this incredible program and to have taken part in the introduction for the lecture's 2019 speaker, Justice Kagan.
Your topic of rule of law, important in all of the years, Bob, that you wrote about it and lectured on it, and it couldn't be more important today as we underscore and fight for the importance of rule of law in this country.
One of the many reasons Bob has excelled as a leader is his unique gift of making those around him believe in themselves and giving them the confidence to achieve their most ambitious goals. In turn, we all believe in Bob and his vision, brilliance, absolute integrity, and deep love for the University of Minnesota Law School.
So Bob Stein, you've done it all over the past 50 years at the law school. You're a great classroom teacher, a productive scholar, a practicing lawyer who's well respected in the legal world, and you're the face of the law school to the outside world in Minnesota and beyond.
Congratulations and thank you, Bob, for all you have done for this great law school.
Bob, I hope this last 50 years is just the prelude to another wonderful 50 years. Best wishes.
Thank you, Bob, for your great long service to the university and particularly to our wonderful University of Minnesota Law School.
Bob, here's to your incredible first half century of teaching success. We look forward to all that will come in the next one. Congratulations again.
Thank you for your great stay, for your great run, and for all you do. May the mutual affection between you and Minnesota law continue forever.
Wow. I'm thinking I should just sit down at this point and thank you, first of all, Dean Jenkins, for that really generous doesn't do it, with a wonderful introduction, so thank you. It means a lot to me. And thanks for all who participated in that video. That was a surprise. I had no idea that was coming. So thank you all for coming today to this occasion. I'm so pleased that my wife Sandy in the front row is here with our three daughters, Linda Stein to her left, and then Laura Stein to Linda's left, and Karen Stein O'Boyle on this side of the aisle, and our granddaughter Erin O'Boyle next to her mother, Mark Conrad, Laura's husband, and Owen Music, who is a good friend of Aaron's. And Sandy's brother, Richard, is at the end of the first row together with his wife, Peggy. So surrounded by family and surrounded by a lot of friends. I'm looking out in the room and seeing so many people here that mean so much to me and are dear from so many aspects of my life. I think the first issue to clarify is, why are we celebrating my 50 years on the faculty now in 2022 when I was appointed to the faculty in 1964? The explanation, and Dean Jenkins touched on this, that I gave up my tenured appointment for several years after I became executive director and chief operating officer of the American Bar Association. And when I returned to the faculty in 2006, I was invited to go through the tenure process once again. It was an interesting experience. Emails were sent out around the country asking for comments on my scholarship. And I would get emails back from friends around the country say, "What the hell is going on in Minnesota? I've been using your book in my course for many years, and now they want me to know about your scholarship." Unfortunately, that tenure review went well, and I was awarded tenure once again. So 35 years as a member of the faculty during my initial appointment, and the 16 years since I came back bring me over the 50-year mark. There are some in the room who took property law from me many years ago, and you may remember in property law we call that tacking the two periods to get us to 51. So it's hard to believe that 58 years have passed since I was invited to join the faculty of the law school in 1964. And what a faculty that was. Dean Bill Lockhart, the lead author of the leading constitutional law casebook in the country. Jesse Chopper, who later went on to become Dean of the University of California, Berkeley Law School. Terry Sandalow, who later went on to become Dean of the University of Michigan Law School. Yale Camisar, who at Michigan is still a leading scholar in the field of criminal law. Arthur Miller, a well-known professor who later moved from here to Michigan and then to Harvard and now is at NYU. And of course, John Cound, the lead author in the leading civil procedure casebook at the time. And then many other distinguished faculty as well. Dean Bill Lockhart contacted me in September 1961, only 3 months after I graduated and had taken the bar exam, to invite me on behalf of the faculty to come back to the school to interview for a faculty position. Excuse my immodesty in telling this story, but I had achieved the highest grade point average in the history of the law school and was the school's first Summa graduate, so that gives some background. And so the faculty reached out to me right after graduation. I had just joined a large national law firm and responded to Dean Lockhart that I was honored and flattered by the invitation, but felt I needed to stay with the law firm I just joined 3 months earlier. Dean Lockhart called me again the next fall in 1962, and I again concluded that I should remain in the firm a little longer. In the fall of 1963, I was again invited to interview for the faculty, and this time immensely honored by the repeated invitations. I agreed to come back to the law school to interview, and I was offered a faculty appointment. It's flattering to be repeatedly invited, and that's a technique I've used myself in faculty hiring through the years. I've had a wonderful relationship with the law school ever since. The faculty voted me tenure after my second year of teaching and scholarship, and I'm so blessed to be a member of this faculty where I have remained to this day, except for teaching at a year teaching at UCLA Law School and for a year teaching at the University of Chicago Law School, and for the years that I directed the American Bar Association. I've had so many world-class colleagues through the years on our excellent faculty here, many of whom are in the room today. And I don't have time to name them all, but I would like to especially note the terrific colleagues who were hired when I was dean and are still on the faculty now. I want to especially recognize Professor Fred Morrison. There's Fred in the third row. Fred joined this faculty 5 years after I did in 1969, but he reached his 50th anniversary before me in 2019 because he didn't have any interruption in his tenured appointment. Fred has been a treasured colleague, and I thank him for being here today. I think this is the first time he's been back to the law school since his retirement, so thank you so much, Fred. And the rest of our current faculty is truly exceptional. I'm enormously proud of the faculty of the University of Minnesota Law School, then and now. When I began teaching, my courses were property, modern real estate, and trusts and estates. There are lawyers in the room who were in some of those courses. After a couple of years, I began teaching estate planning, a largely tax course, and I taught a variety of seminars through the years, and one that I particularly enjoyed was a legislative drafting seminar in which each of the students would draft a proposed Minnesota statute, and then the students and I would look for authors among the senators and representatives in the Minnesota legislature and get those draft statutes introduced, and many of them ended up being enacted into law. I also especially enjoyed teaching an estate planning drafting seminar, which I consider to be a simulated clinical course, and the students would develop estate plans for clients in a variety of situations. Since I returned to the law school in 2006, I have changed my teaching focus. I now teach a constitutional law course on the United States Supreme Court in great cases that have shaped the nation, in which I teach constitutional law through 25 nation-shaping cases. I also teach a seminar on the rule of law that the dean mentioned that reflects the rule of law reforms that I was involved with in many parts of the world during the time I was the executive director of the American Bar Association. But I don't want this lecture to be only a series of reminiscences, however enjoyable or not that might be. All of my chair lectures through the years have been forward-looking and have related to a subject I was then teaching or an administrative responsibility I then had. Today, I would like to talk about some thoughts about current criticisms of the Supreme Court of the United States, and this lecture too relates to the course I now teach on the U.S. Supreme Court and great cases that have shaped the nation. The Supreme Court has come under a great amount of criticism in recent years, particularly after decisions in the last term that overruled long-standing precedents such as Roe versus Wade. In addition, in that term, the court allowed more statutory restrictions on abortion. The court also shifted the line separating church and state and began to rein in the discretion of government agencies, among several other truly remarkable decisions. And the pace of change by the court may continue in the current term that began the first Monday of this month as the court has agreed to hear cases involving 1, a challenge to affirmative action programs at Harvard and North Carolina, 2, a voting rights case involving an allegation that Alabama discriminated against African Americans by gerrymandering election districts, and 3, the issue of whether laws forbidding discrimination on the basis of sexual orientation must give way to business owners claiming a right of free expression. And those are only 3 of many huge cases the court has taken up this year. Criticisms and proposals to quote, unquote, reform the Supreme Court have been made by scholars, journalists, members of other branches of government, and these criticisms and proposals have received wide commentary. Some criticism has even come from within the court itself. In a remarkable exchange, one I don't quite recall in recent years, after Chief Justice John Roberts delivered a speech defending the court and saying unpopular decisions should not call the court's legitimacy into question, Justice Elena Kagan countered in remarks at a law school this past summer, quote, disregarding stare decisis, the doctrine of abiding by past decisions in the absence of compelling evidence that change is required undermines public confidence, unquote. In the time I have today, I'd like to discuss some of the so-called reform proposals and express my views on those proposals. A presidential commission on the Supreme Court of the United States has been appointed and issued its final report in December of last year, and I will note some of the conclusions of that commission. Following those remarks, to the extent time is available, I would like to talk about some of the justices I have admired the most among the 116 justices that have been appointed to the Supreme Court in the 232 years since the court was established in 1790. I'm currently working on a book to describe 25 of the most notable justices of the Supreme Court, and I think I see some of my research assistants in here who are helping me as we work on that book. One of the proposals that has been made to reform the court is to increase the number of justices on the Supreme Court. Critics of the current Supreme Court have urged the appointment of additional justices so that the views of the new justices, together with those of the current members of the court, would create a new majority on the court. Now, the size of the Supreme Court is not mandated in Article 3 of the Constitution. It is decided by law by Congress. The size was set by Congress at 6 justices in the first Judiciary Act of 1789, and the Congress planned to increase the size of the court as the population of the United States increased. The size of the court was increased to 7 justices in 1807, reflecting the increased population. The size of the court increased to 9 justices in 1837 and increased again to 10 justices in 1863. President Lincoln was the only president to appoint a 10th justice on the Supreme Court. In 1866, the Republican Congress wanted to not deny President Andrew Johnson, a Democrat who succeeded to the presidency upon the assassination of President Lincoln, deny him the ability to appoint any Supreme Court justices after unsuccessfully trying to impeach him. Congress passed the Judicial Circuits Act in 1866 that provided that the next 3 justices to retire or die would not be replaced until the court reached the size of 7 by attrition. 1 justice was removed in 1866, so the court became 9 justices. A 2nd justice was removed in 1867, and the court became 8 justices. And by 1869, President Andrew Johnson was no longer president, and there was no longer concern about him having any appointments to the court. And so Congress passed the Circuit Judges Act of 1869 that set the size of the Supreme Court at 9, where it has remained ever since for 153 years. Now, as many of you know, President Franklin Roosevelt attempted to increase the size of the court in 1937, President Roosevelt was frustrated by a 5-justice conservative majority on the court holding unconstitutional several important acts that were part of Roosevelt's New Deal package of legislation. And so he proposed this bill that would add one new justice to the court for every justice who had reached age 70 and had not retired until the court reached the size of 15 justices. The plan was commonly described as Roosevelt's court packing plan. Interesting, the dean mentioned I hold the Everett Fraser Professor of Law. Everett Fraser was a great Democrat, and he went out lecturing all over the country back at that time in favor of President Roosevelt's plan to increase the size of the Supreme Court. But the plan ran into a lot of opposition in Congress, and it probably would have ultimately failed. It didn't actually die, but it was near death. But suddenly, the larger court was no longer necessary for passage of Roosevelt's New Deal legislation. In the 1937 case of West Coast Hotel versus Parrish, Justice Owen Roberts, who frequently was part of the 5-justice conservative majority, changed his mind, switched his vote to uphold the constitutionality of state minimum wage legislation, and so the blockade of 5 conservative justices was broken. That vote change has been called, many of you are familiar with this, the switch in time that saved 9, saved the court at 9. Also in 1937, President Roosevelt had an additional appointment to the court to fill the seat of one of the conservatives, Justice William Vandeventer, who retired, and Roosevelt appointed Alabama Senator Hugo Black to the court. And Black had been a supporter of the court packing plan, but he commended himself to President Roosevelt, and so he was the first appointment Roosevelt made to the Supreme Court. And so the court has remained at 9 justices, where it continues today. I do not support an increase in the size of the court above 9 justices, as many have proposed, in order to achieve a new majority. In politics, I believe that what goes around comes around. And if one party does this to protect its constitutional priorities, there's nothing to prevent the other party from increasing the size of the court further when it comes into power. And so the 9 may become 12, and the 12 may become 15, and so on. And for those reasons, I'm very doubtful about the benefit of the increase in the size of the court. In my opinion, the case has not been made that a larger court would produce better decisions. In fact, the court is taking fewer cases now than it has for decades. When I started teaching, they were taking some 200 cases or more a year. In recent years, they're taking 50 to 55 cases a year. So it's a much smaller workload of the court now than previously. So I do not support an increase in the size of the court. The Presidential Commission on the Supreme Court was divided in their views on this proposal, and so the commission took no position on the proposal to increase the size of the court. A second reform proposal has been to limit the terms of the justices from a lifetime appointment to a non-renewable term of significant length. It's often been suggested, such as 18 years. In fact, and these are interesting figures to me, the average length of the terms of justice has become longer in recent years. From 1789 to 1970, about 50 years ago, 1789 to 1970, justices served an average of 14.9 years on the court. Justices who have stepped down after 1970, the last 52 years, have served an average of 25.6 years on the court. That's an increase of more than 10 years in recent years in service on the court. And the retirement age has increased from an average of age 68 before 1970 to age 79 for justices retiring after 1970. Between 1789 and 1970, there was a vacancy on the court once every 1.91 years. In the 50 years after 1971, there has been a vacancy on the court once every 3.75 years. So you see the terms are getting longer and the openings spaced out much further. The Constitution sets the length of the term of federal judges, including Supreme Court justice, as a lifetime appointment. A change in the term of Supreme Court justices would require a constitutional amendment, and that's the principal reason I am not supportive of a change limiting the term of justices to one long, non-renewable term such as 18 years. A long, non-renewable term might be reasonable, but I'm concerned about the constitutional amendment process. Once the Constitution is open for amendment, some very undesirable results could occur, and that could result in the loss of critically important civil rights. There are two processes for amending the Constitution, and one of them would be calling for a constitutional convention. If that process was followed, any of our precious existing constitutional rights might be threatened by the actions at the convention. Everything is on the table if that occurs. I believe it is important to protect the Constitution from changes that result from the passions of the moment. Also, I would note that some of the greatest opinions by great justices occurred after they had been on the court for more than 18 years. Let's take Justice Ruth Bader Ginsburg, for example. She became the notorious RBG who led the liberal wing of the court primarily after she surpassed her 18th year on the court in 2011. There was support for term limits for justices on the Presidential Commission on the Supreme Court, but it was far from unanimous. The commission report listed the arguments for and against term limits. Now, another proposal for change in constitutional law that has been advanced is a constitutional amendment that would allow a Supreme Court judgment declaring a federal law to be unconstitutional to be overturned by a 2/3 vote of both houses of Congress. There's some precedent for that idea in Canada's Charter of Rights and Freedoms, in which a, quote, notwithstanding, unquote, clause allows a parliamentary override of a Canadian Supreme Court decision holding a Canadian statute incompatible with a charter-protected right. The Canadian Parliament has yet to exercise that prerogative. Now, that Canadian provision was brought to my attention a few years ago when Justice Ruth Bader Ginsburg sent me a speech she delivered to a U.S.-Canada Judicial Conference in which she discussed that provision. She was a good source of material for my seminars. I would get copies of her speeches pretty regularly. Justice Ginsburg did not support the concept, and neither do I. Another proposal that has been advanced for change in the operation of the Supreme Court would be the adoption of a judicial code of ethics for the justices. There is an advisory code of conduct covering all other federal judges, but that code by its own terms is not applicable to the justices. I think it would be desirable for the court to adopt a code of ethics or a code of conduct applicable to Supreme Court justices. That would address concerns that have arisen when justices participate in cases when there is concern about an alleged conflict of interest. In my view, it would be preferable for the court to adopt its own code of conduct rather than have one applied to it that is enacted by Congress. If a congressionally enacted code would raise separation of powers issues. The Presidential Commission on the Supreme Court commented favorably about adoption of a code of ethics or a code of conduct for the Supreme Court, but did not make a formal recommendation on the question. There is a change that I believe would reduce some of the current criticisms of the Supreme Court, and that is a change in the Senate rule for votes to confirm Supreme Court nominations. Before 2013, the Senate rules required a supermajority for confirmation of judicial appointments. To end debate or a filibuster about a nomination, the Senate rules provided for a cloture vote to end debate. The percentage of votes required to end debate has changed over time, but in 2013 and now, the cloture motion to end debate requires 60 votes to be approved. That essentially established a requirement of a supermajority to confirm judicial appointments. In 2013, when the Democrats had a majority but not a supermajority of the Senate, Democratic senators were worried that the cloture rule would prevent some of the judicial appointments by President Obama to receive a confirmation vote because they lacked the necessary 60 votes of senators to invoke cloture. As a consequence, the then Senate leader, Senator Harry Reid of Nevada, was successful in leading the Senate to change its rules to eliminate the cloture rule for nomination of federal judges other than Supreme Court nominations, and those nominations of judges other than Supreme Court justices could be approved by a vote of a simple majority of the Senate or 51 votes. But after 2013, the Senate rules still applied the cloture rule to votes to confirm appointments to the United States Supreme Court. In 2017, Senate Republicans had a majority of the Senate, and they were successful in removing the cloture exception for Supreme Court nominations. After that change, all judicial nominations, including nominations of Supreme Court justices, can be confirmed by a vote of a simple majority of the Senate, 51 votes. The appointments of President Donald Trump's 3 Supreme Court appointments and President Joe Biden's single, so far, Supreme Court appointment were confirmed largely along party lines. Justice Neil Gorsuch by a vote of 54 to 45, Justice Brett Kavanaugh by a 50 to 48 vote, and Justice Amy Coney Barrett by a 52 to 48 vote, and Justice Ketanji Brown Jackson by a 53 to 47 vote. I would like to see the cloture rule reapplied to all judicial appointments, but particularly to Supreme Court nominations. That would require that most Supreme Court nominations receive some amount of bipartisan support. I believe that would reduce some of the polarization that currently exists regarding Supreme Court appointments. I would be in favor of a change in the Senate cloture rules to require a supermajority of 60 senators to confirm nomination of a justice to the Supreme Court. The Presidential Commission on the Supreme Court considered other proposals for change in the structure and operation of the Supreme Court, but I believe the proposals I have discussed are some of the more significant ones. I would like to move to the remaining part of this lecture and talk about some of the notable justices that I particularly admire in the long history of the Supreme Court. These are justices who have made extraordinary contributions to the development of constitutional law that established our nation and protects the freedoms that we cherish. I wish there was time to talk about many more of my heroes on the court, but I hope I've reserved enough time to talk about 4 of the great justices who have served on the court. I begin with the great Chief Justice, and I think many of you know who I'm talking about, Chief Justice John Marshall. I regard Chief Justice John Marshall as the greatest Chief Justice in the history of the Supreme Court. He was not the first Chief Justice. I think many people can't remember who was Chief Justice before him. Chief Justice Marshall was the 4th, but he was the Chief Justice whose leadership and decisions helped to create and strengthen a new nation out of the quarreling 13 states that came together after the Declaration of Independence. Marshall had never been a judge before President John Adams appointed him to the court. He was a politician, serving as a Federalist congressman in the House of Representatives until he was appointed to be Secretary of State in the John Adams administration. He had no judicial experience before he became Chief Justice. What Chief Justice Marshall had was a vision, and I've studied these justices. I think so often visions are important to success in life, where people want to go with the responsibility they have. Marshall had a vision of a new nation, and he had incredible ability to persuade other justices to support this vision. Most of his legendary opinions were unanimous. Through many nation-building cases, such as Gibbons versus Ogden, in which he interpreted the Constitution to give the Congress of the new nation extraordinarily broad power over interstate commerce, indeed broader than anything since. There's no decision that's given Congress broader power than Gibbons versus Ogden by Chief Justice John Marshall. But also his decision in Marbury versus Madison, where he completed the separation of powers of the three branches of government by holding the Supreme Court had the power to hold acts of the Congress, and by extension, acts of the President, unconstitutional. Marshall helped to build the new nation in which all the branches of government have co-equal powers. In the 34 years he served on the court, he was principally responsible for bringing about the reality of a new nation. My opinion, he is the great Chief Justice. The Chief Justice I regard as the second greatest Chief Justice in the history of the Supreme Court is Chief Justice Earl Warren. Like Marshall, Warren had never been a judge before becoming Chief Justice. He too was a politician. But what a politician. He was a Republican who had broad bipartisan support because of his centrist to liberal views. Warren ran for governor of California and won in 1942. He ran again to be governor of California in 1946. He won the Republican primary election to be the Republican nominee for governor. He entered the primary election of the Democratic Party, and he won the Democratic primary as well, so he was the Democratic candidate. And there was an Independence Party that had a election, and he won that too. So he was the primary, he was the representative of every party in 1946, so he won the election. And it shows his skills, like Marshall, in people skills, in interacting with people of various views. In 1948, Warren was on the national ticket as a candidate for vice president on the ticket with Senator Robert Taft, and that ticket was barely defeated by the President Truman ticket. You may remember an early edition of some of the older ones of the Chicago Tribune said that the Taft-Warren ticket had been elected. It was that close an election. So Warren was a politician with great people skills like Marshall, and he also brought a vision like Marshall to his leadership of the court as Chief Justice. And the cases that came up, which I'm teaching now in my course, and it's just mind-boggling that every year, 1961, 1962, 1963, there was a blockbuster case every year, and that was Warren finding those cases and bringing them to the court. Warren's vision was of a new and different nation, an America in which there was less racial discrimination, a nation in which the criminal justice system was more just, and a nation in which every person was entitled to an equal vote. In the first weeks after he came on the court, and he even before he was confirmed, it was an appointment in between terms. He led the court to a unanimous decision in Brown versus the Board of Education, overruling the 50-year history of Plessy versus Ferguson that supported legal education through the doctrine of separate but equal. The court had tentatively voted the year before Warren joined the court to decide Brown by upholding the rule of Plessy versus Ferguson. That is, to hold that the black and white schools were separate but not equal, and find that as a mechanism for giving the plaintiffs relief. The court was uncomfortable with that result, so they put the case over for argument again in the next year. The only change in the next year was that Chief Justice Warren had replaced Chief Justice Vinson, who died a month before the next term was to begin. Warren came on the court 1 month, not even a month, it was September 12th, and the court met the first Monday in October. And he, as a result of his presence on the court, the 4-5 vote of the previous year became 5-4 to overturn Plessy. It would not have happened if Warren had not gone on the court. Warren knew how important it was that this nation-changing case be unanimous, so he went chamber to chamber persuading all of his colleagues to join the majority opinion. This all in the first year of the Chief Justiceship of Earl Warren, who had never previously been a judge, and he came on to a court with such iconic, legendary justices as Hugo Black, Stanley Reed, Felix Frankfurter, Douglas Jackson. It's an amazing accomplishment by Earl Warren. In the 14 years he was Chief Justice, Warren led the court in deciding Baker versus Carr that required that every person should have his or her vote count equally, and Gideon versus Wainwright that established the right to counsel in criminal cases. And incidentally, Walter Mondale led the state attorneys general to file an important brief in that case. Mapp versus Ohio that greatly expanded the protections of the Fourth Amendment privilege against unreasonable searches and seizures. And I guess most of you can recite from memory the Miranda warnings that he wrote in his opinion in that famous case that expanded the right to be protected against self-incrimination. The Warren Court from 1954 to 1968 ranks as a high point in the development of constitutional law to achieve greater social justice in America. Moving to more contemporary justices, I would like to talk about two justices for whom I have such great admiration and fondness. Justice Sandra Day O'Connor, the first woman to be appointed to the Supreme Court, and Justice Ruth Bader Ginsburg, the second woman to be appointed to the court. Both were giants on the court, and I was blessed to have the friendship of both of them for many decades. Justice Sandra Day O'Connor was the first woman appointed to the Supreme Court, appointed by President Ronald Reagan in 1981. It's interesting that she, like Marshall and Warren, had been a politician, the majority leader of the Senate in Arizona. And in fact, not only that, she was the first woman to be president of the Senate in any state in the United States. So she'd been a successful politician before going on the court, and she is the last justice appointed to the court to have legislative experience. I believe the current court would benefit from the appointment of a justice that has had legislative experience. The subtitle of a biography of Justice O'Connor by Joan Biscopek describes her time on the Supreme Court with these words, quote, how the first woman on the Supreme Court became its most influential justice, unquote. She was a swing justice who could attract votes to an opinion from both conservatives and liberals. This is reflected in her opinions in Grutter versus Bollinger, which was an affirmative action case, and in Planned Parenthood versus Casey involving the right to an abortion. Some criticized Justice O'Connor for lacking a controlling judicial philosophy, but what she had was a great practical sense of justice. A tact of knowing what would be widely viewed by the public as a just decision. In recognition of her appointment as the first woman appointed to the Supreme Court, the women graduates and students of this law school had a reception in her honor on the first Monday in October 1981 when she first sat on the Supreme Court. Is anyone in the room who was at that reception? Yep. What a mountaintop experience, wasn't it? Justice O'Connor sent us a greeting to be read at that reception on her first day on the court. She accepted my invitation to visit Minnesota when she could, and she came in 1987, on which visit the University of Minnesota awarded Justice O'Connor an honorary Doctor of Laws degree. Justice O'Connor made additional visits to the law school in subsequent years, and in introducing her to an audience on a later visit, I described her first visit in 1987 in these words. Most of us in the room were old enough to remember this, but, quote, if you were not old enough in 1981 to be aware of her appointment, it may be hard for you to fully appreciate how electric and powerful that moment was in American history. As I walked with Justice O'Connor in those days of 1987 when she was here, I was astounded at the powerful impact her appointment to the court had on people, but particularly on women. Wherever we went, crowds of women would press forward, many, it's not an exaggeration, with tears running down their face, many just wanting to touch her. She represented such a momentous step forward in opportunities for women in this country. She represented the American dream for women, not just in law, but in all fields of endeavor. So I'm very proud of Justice O'Connor's appointment to the court and certainly her work on the court. The fourth justice and final one I would like to talk about briefly today is Justice Ruth Bader Ginsburg, who was a friend for over 40 years before her sad death in 2020. We met when she was a professor at Columbia Law School and I was a professor here. Later, I would visit her each year when she was on the DC Court of Appeals, and still later, a justice on the Supreme Court. I was there interviewing clerks who were interested in law teaching and would always arrange a visit with Ruth Ginsburg. She was our graduation speaker here during the time she was on the Court of Appeals, and she was the first justice to participate in a conversation with me as part of the Stein series that was referenced earlier. We also served together on the Council of the American Law Institute for many years and the ABA Center for Human Rights. So we had many connections, very fond of Justice Ginsburg. We have several Swedish students in the room today who are exchange law students. And I'd like to note that the first position Justice Ginsburg had after her law school graduation and a federal clerkship was as associate director of a project on international procedure, where she learned to read and speak Swedish, and she co-authored a book on civil procedure, also in Swedish. In 1969, Lund University in Sweden conferred an honorary degree of laws on then Professor Ginsburg, and in 2019, near the end of her life, within a year of her death, she traveled to Sweden to be honored by Lund University as a Jubilee Doctor on the 50th anniversary of her honorary degree. In 1973, Ruth Bader Ginsburg became General Counsel of the American Civil Liberties Union Project on Women's Rights, which she had founded, and she argued many groundbreaking cases that expanded constitutional rights for women. Later, as a judge, she also authored the majority opinion in landmark cases recognizing the constitutional rights of women, such as U.S. versus Virginia, striking down the male-only admissions policy of the Virginia Military Institute, VMI. I believe that no justice is more responsible for the advancement of women's rights in the last 25 years than Justice Ginsburg. Even her dissenting opinions, as in Ledbetter versus Goodyear, have become legendary. In introducing her on one occasion, I said no justice had done more to advance constitutional rights of women than she had, and she stood up and corrected me to say she had worked to advance the constitutional rights of all persons, including women. In the last 10 years of her life, Justice Ginsburg became known as the notorious RBG. She thought that was very funny and was so pleased by that description. I saw her almost every year in the last several years. And each time I visited her office, she would take me over to a table in which she had all kinds of memorabilia displayed to show me the many T-shirts and other golf balls and things that say Notorious RBG. Justice Ginsburg's death in September 2020 was such an overwhelmingly sad day for all of us who treasured her leadership on the court in extending the constitutional and protections for all of us. So I thank you for the opportunity to share with you some of my thoughts on current criticisms of the Supreme Court and to acknowledge some of the most notable Supreme Court justices for whom I have such enormous admiration. Currently, in my 51st year on the law school faculty, I'm so pleased to teach about and write about our great Supreme Court and the marvelous justices who have developed our constitutional law over the past 232 years. And let me close with a teaser. I'm pleased to announce that one of the current justices of the Supreme Court has agreed to come to Minnesota in the next academic year for a conversation with me as part of the Stein Lecture Series. Thank you very much. Can we take a couple of questions? Thank you so much. That's very kind of you. I don't want to cut into our refreshment time too far, but Let's take a couple of questions if anyone has any. Yes, Gary? I think he said it was a damn fool mistake. Yeah. There's a funny story behind that. Eisenhower wanted to get, they were worried about the 56 election. So, and thought they might need some support in the Northeast where there are a lot of Catholics. So Eisenhower said to his attorney general, whose name was Brownell, said, do a little research and find a judge in the Northeast who's a Catholic, appeal to the Catholic vote. So Brownell read a speech that Warren had given and thought it was conservative. And so it was pretty, oh, excuse me, I'm conflating two words. In the case of Warren, that goes back to the election of 1952 when Warren was running for president and Eisenhower was running for president. Eisenhower wanted Warren's support. So he said, Warren said to him, look, I'll give you my support if you make your first appointment to the Supreme Court to me. And Eisenhower agreed to that. Well, then Vinson died in September of 1953. And so Eisenhower, again, went to the same Attorney General, Brownell. Brownell gave him bad advice on a lot of occasions. Brownell, he said, call up Warren and ask him what I promised him. Did I promise him the first associate justice position or the first chief justice position? And Warren said, you said the first justice position. And so that's how Warren got on the court. Time for, yeah.
I have a microphone over here. Perfect. Let's have this one be the last one because we do have a microphone upstairs and there's plenty of time upstairs to ask Bob some questions.
Dean Stein, many of us were privileged to read the beautiful letters that you crafted to alumni over the years, giving us the updates on the law school. Who, in your mind, are the greatest writers among the Supreme Court justices over the years?
Oh, there's no question. Robert Jackson. It's hands down. There's no one that was as eloquent as Jackson. In fact, even his speeches, he was, as you may know, he sat in the, he was a prosecutor in the Nuremberg prosecutions after the war, and his opening statement in that case is in books as one of the great speeches of the 20th century. His opinions were like poetry. In the Barnett flag salute case, it's a beautiful opinion. So he was by far the best writer. Opinions to me are like fingerprints. When you read them, you can kind of, like Harry Blackman had a technique that was kind of funny. He'd like to recite history at the beginning of his opinions. So he had, one of his cases was Curt Flood, a baseball player that challenged the rule that let baseball owners control the future of the players. And so he starts out the opinion for a couple of pages talking about the greatest baseball players ever. There's Mickey Mantle, and and similarly in the abortion decision, Roe versus Wade, he starts out the opinion talking about the history of abortion, going back to the Code of Hammurabi and all the medical opinions. So it's fun to get to know the opinions of the court, but clearly I would put Jackson head and shoulders above every other justice. Okay, that's it for now. We'll see you upstairs.